Hello, and welcome to the fourth of my series on the Consumer Bankruptcy Reform Act of 2020. I'm Dave Giddens with the law firm of Giddens & Gatton Law, PC in Albuquerque, New Mexico. My firm practices primarily in the areas of bankruptcy and creditors' rights throughout the state of New Mexico. In my previous program, we took a quick look at the proposed elimination of pre- and post-petition credit counseling and financial management education. Today, we will look at change number 3. The 341 meeting may be conducted remotely. Under the CBRA, upon request, 341 meetings can be conducted remotely and scheduled so that they do not interfere with the debtor's work schedules. We have learned during the COVID-19 pandemic that 341 meetings work just fine when they are conducted remotely. In New Mexico, we do them by phone. Under CBRA, the 341 meeting may be in person if it is not burdensome on the debtor and does not require more than minimal travel. The travel issue is a big deal in New Mexico for debtors who live in rural areas. Another benefit of telephonic 341 meetings that we have discovered is that attendance by the attorney at the 341 meeting is less expensive when you don't have that hour-long round trip to the 341 meeting room. As I mentioned in my last broadcast, we don't yet know whether or not the CBRA will become law. However, you should know that there is legislative activity relating to bankruptcy. Senator Dick Durbin and Senator Chuck Grassley introduced the COVID-19 Bankruptcy Relief Extension Act, which is bipartisan legislation to temporarily extend provisions that were enacted as part of the March 2020 CARES Act. The December 2020 Omnibus Appropriations Bill also extends for an additional year CARES Act bankruptcy provisions that are set to expire on March 27, 2021. Included in the nearly 5,600-page Consolidated Appropriation Act are a number of new protections for consumer bankruptcy debtors. These provisions took effect when the President signed the bill on December 27th of 2020, and they will sunset 1 year after enactment on December 27th, 2021. The most significant change will permit debtors to receive a discharge in a Chapter 13 case despite having missed mortgage payments due to a COVID-19 hardship or because the debtor has received a loan forbearance or modification. Other amendments protect stimulus payments in a bankruptcy case, prohibit debtors from being denied a CARES Act forbearance if they have filed bankruptcy or received a discharge, permit consumers to have utility service maintained or restored after filing bankruptcy without paying a deposit, and create a procedure for filing a supplemental proof of claim for amounts that were forborne under a mortgage forbearance. If the COVID-19 Bankruptcy Relief Extension Act becomes law, the December 27 sunset of the changes contained in the Consolidated Appropriations Act would be extended to March 27, 2022. Stay tuned. In my next broadcast, we will look at another proposed change contained in the CBRA, and we'll see what else, if anything, is happening in Washington. In the meantime, be well and stay safe. Have a great day.